have a request that the microphones move down a little bit and try to get about 6 to 8 inches away so they can get everything you say. Apparently, they've heard everything that Mr. Lawless has said.
Big ass
No, your voice is carried, but for the rest of us, just speak into your microphones when you have a chance to do that. And Ms. Capps, I think you're first up, and this is certainly not the second floor of the Supreme Court building, so it's good to see you again. And I think Mr. Lawless is going to begin
Yes, sir.
the question.
Hello.
Hello.
It's good to see you face to face
Nice to meet you in
today
person
after
as
our
well.
conversations earlier. And I made it without getting lost or anything.
You ain't
Okay,
from
are
here?
you relaxed?
I'll do my best.
Well, just, we had that discussion that it was most important for you to, and you appear to be there. All right, let's start, and again, first off, let me say thank you for your application, and thank you for putting yourself out there. For all the applicants, this is not an easy thing that you do. I wouldn't do it. But, and since I haven't been able to say this to anybody yet, I wouldn't do it. I couldn't afford the pay cut, but for some of y'all, it's not necessarily a pay cut, state employees.
Mr. Spitzer's not here to comment, so.
Understood. But your application and your position comes to us a little bit different than a lot of the other people that have come today, and we discussed this. And obviously, you write well, really well.
I
And
hope that's the general
it,
consensus.
well, you're still there, so
Yes.
you're passing your test. Explain a little bit your background, because it is so much different. You haven't been in the courtroom trying cases and articulating to people. Well, you probably have articulated to my my friend next to me, and he is familiar with you. But explain a little bit what you do, because you sort of have been in the job of grading papers, as they say sometimes.
So I have talked to Judge Thomas at length about how to go about this, addressing the monkey, in the elephant in the room, as the proverbial, as they say. I'm going to get the question of how many jury trials have you had? And the answer is 0. That doesn't mean I've never been in a courtroom. I've been in plenty of courtrooms. I worked for D. Army Bailey in the trial court level. Back in those days, I'm a little bit older than I look, so we had books that you wrote down the motions in. There was no electronic filing. There were just big, large books that sat in the Shelby County Circuit Court clerk's office. And so it was my job every Friday to go and get that information, pull the dockets, put it together for Judge Bailey. Judge Bailey was apparently not as good as Eldridge time or Lancaster time, Judge Bailey, but he was an exceptionally learned man that I learned a lot from in that 1 year that I worked for him while I was in law school. I too am a West Tennessee transplant. I was born and raised in Memphis. So it seems to be a general theme happening. I went to, Mr. Spitzer talked about school. I was accepted at the University of Memphis, and I was accepted at the University of Tennessee, and I was accepted at Baylor. But my goal I was 20, so I started law school at 20 years old. Some people, that could be seen as a deficit, but, I think I was motivated. I was motivated from the very beginning, and I was the second or third youngest in my class, just behind Miss Bhattacharya, that Judge Koch actually did hire as his law clerk. And so I went to the University of Memphis. I wanted to stay in Memphis. Me standing here before you as a citizen of Anderson County for 10 years was not on the books. I worked in Jackson, Tennessee, I've worked in Nashville, Tennessee, and now I've worked in Knoxville for 10 years for Judge Thomas. And so I like to say I'm the volunteerist of them all. I have been in all Supreme Court buildings. I have had offices in all Supreme Court buildings. And I, through that, have had to get experience with a lot of different judges, a lot of different personalities. I worked for 3 of them, which makes me have to, you think you do the same job, but you don't do the same job. Each judge is different. Each judge's principles, perceptions, they're all different. And so I have to learn their unique particular style. And, I have been lucky to work with 3 men that I've really admired and that have been great bosses and very kind to me. But to address the lack of trial experience, so what we do is we take a case from beginning to end. I get the whole box from everything that's happened here in Anderson County. And it comes into my office, and I read it from beginning to end. Technical records, we're very, in the appellate court, we still have the green folder, so we do e-filings now, by the way, and have since my time at the Court of Criminal Appeals. Jim Hivner has been instrumental in getting e-filings implemented with the Court of Criminal Appeals, and so it is not a requirement, but all of our records are now digitized. So even if a pro se defendant comes in and can't afford or happens to be incarcerated, they're scanned in and the record is still there for all to see. So that, Justice Koch was one of the first who got 2 monitors in his office. And so now we all have 2 monitors in our office. But I take that from beginning to end, and I've probably worked I've worked for the court for 19 years. I've worked for the Department of Commerce and Insurance for a little over a year. So in that 19 years, I've probably read close to 1,000 jury trials from beginning to end. I was not an advocate for a particular side. We talk about how it becomes different, right? If I'm in here, my job as judge is not to be an advocate. It's to listen to the advocates. It's to listen to the parties. It's to adjudicate. And so I have seen good trial judges. I've seen bad trial judges. To say I don't have any knowledge of the rules of procedure would be disingenuous. I mean, I am inundated sometimes with the rules of procedure and evidence. I've written cases and from beginning to end that analyze rules of evidence. Our opinions as the years have gone on have gotten much more complicated legally. When I first started, we weren't that far out from typewriter opinions. We still had law on the disc. We didn't have any contract with Westlaw or Lexis. So, those opinions have gotten much more complicated. Our jobs have gotten, we're behind. I'm behind the scenes. I'm a person behind the scenes. I'm not, but I'm ready to step out of that shadow. And I think my experience in taking those cases, and we are also 100% criminal. I've worked on death penalty cases. I've written a death penalty opinion. I have seen some extremely gory crimes, extremely, and I think as time progresses, whether or not you're never comfortable with it, some of the violent and the horrible things people do to each other. But it does become a part of, I don't talk about my work even now outside of the office because it is dirty in some ways and it is hard to deal with. And so when I go home, I want to watch, something, I want to watch Cruella or, something that is not, to take my mind off the difficult things that we see every day. And so, I think with all of that together, and I have learned from some of the best around, and I have many conversations, and they've also helped me through this process. They've reviewed my application, they've sat with me, and they've talked to me. And, Judge Thomas says to me, just because you're a good trial lawyer doesn't mean you'll make a good trial judge, And so I think I have had that experience, and like I said, I'm ready to move forward. So I hope to any extent that is a negative, that you'll see it as a positive, that I've actually been in the process of adjudicating things. I worked for judges who didn't even know, we talk about senior, Judge Hayes didn't even use his own email. His secretary sent, he would stand behind me while I typed the opinion and read from the books. Judge Wells typed with one finger. So to say, we didn't have any involvement in those cases or that some of that wasn't, that I wasn't integral in those decisions, I think they will say they couldn't be the successful people that they are without us. And so I think all of us, people behind the scenes, hopefully have, recognized as important.
So some might say, well, why don't you, based on your experience, go for an appellate opening versus the trial court, and we sort of talked about that, but you were going to think a little more on it. I mean,
Well, typically, in my experience, from what I've seen, appellate court law clerks or staff attorneys, I have seen them appointed as trial court judges. I have never seen one appointed as an appellate court judge. Not to say that it couldn't happen, but to go straight from my position to an appellate position has not been done. Not to say that, at least that I'm aware of. I know Judge Childers, who's in Dyer County, was the staff attorney on the civil side in the western section. And I believe there's been some others that have come from positions like mine that have gone on to make good trial judges. But, I feel like we need that experience. An appellate court is even a more prestigious job than we're here interviewing you for the commission. And so I think, that they look for a little bit more experience than somebody in that role, since there are only, if we count 29 of them statewide, to be pretty, a lot of them are trial court judges that have made the leap to become on the Court of Appeals.
Your application, you mentioned, and you and I did talk about this, because it's one of the few times I've seen it, where you were in a fraternity,
Yes.
using the correct phraseology here,
Zeta is a
because Zeta
fraternity,
Tau Alpha
yes.
is a fraternity, not a sorority.
It is
So we're
not.
not, but you classified that as, and I throw this out there because I did the same thing up in Montgomery County, self-identify its members as women.
So with-
Okay, this is a new world that some of us are evolving into. So you have someone before you, and you're doing a domestic case, right? And this person, and I think we talked about this, is the custodial parent. And it's a birthing person, I think is the new phraseology. I've got this look over here. That was pretty. I'd never heard of it either, but that's neither here nor there. Where am I going?
No telling.
Okay. And it's a takeoff of the sovereign citizen type of questioning that I gave earlier, or that I used earlier. So you've got a hotly contested domestic case, and a minor child wants to change that identification, and the mom is all for it, but the dad is adamantly opposed to it. You've never been on the trial bench. You've never tried a domestic case like my friend from Chattanooga has. How do you approach your analysis of that? Because now you're looking at it as what you do know.
Right, so after we talked, I did a little bit of research, because again, it's also not something, it is a new issue for all of us, I think, whether you would be on the trial bench, have done anything with, before or not. The gender equality issues that come before the court are new, and to say that I would know and be prepared for every single thing, I think I'm a quick learner. I think that's what I was trying to get at with being young and motivated, and, I did some research on that issue to kind of put my finger on what was happening in that area of the law, because it wasn't something I was familiar with. And I looked at that some states are enacting laws that gender surgery can't happen until you're 18 or older. Some are more on a case-by-case basis. But I think if there were two parents who disagreed about having that type of surgery, or that I would be hard-pressed to do that. But I think you'd need expert opinions, psychological opinions. I don't think, that would be something that, I think the reference I made to you was, it's not like a tattoo that I can have removed later on, And so, but those issues are coming before the court, and, children that are prepubescent and that are wanting to try to change, or start to transform at a young age. And so I personally, if the parents can't agree, it would be difficult to convince me. I'm not saying that I couldn't be convinced. I think to always I think even when we write opinions, even the Supreme Court, we try to always stay away from absolutes, that there's never, we'll say there's no bright line. We don't really like bright line rules. So I think that's how I would deal with it, would be, to listen to the experts, to listen to the psychologists, and to evaluate the parents and what's really going to be in the best interest of that child.
We also talked about computers,
We did.
and we talked about moving a great leap forward, so to speak. What would you undertake? Because obviously you've studied the position, you know the procedures going on around here. How would you suggest to the circuit court clerk bringing about change to upgrade? I'm not going to say bring it forward. Let's say upgrade to make it more in tune with the processes that are going on now throughout the state.
I think that we've talked about a large focus about e-filings in here. I think there are some, I am not intimately associated with what happens in Judge Eldridge's courtroom. I would certainly want to be more informed about the things that he's implemented, how those might be excellent programs to be continued or upgraded as may be. But to talk, the circuit court clerk should, when we talk about e-filings, and I know Mr. Hibner, the appellate court clerk, we got a lot of pushback from that in the beginning. We don't like to do change, right? And I had a lot of judges who, again, typed with one finger and really wanted, and we still have paper copies, but, you have to have involvement from all parties. And Hibner didn't do it alone. He worked with the Supreme Court justices. They implemented rules that took time. It wasn't a deadline of, on April 1st, you have to make a filing, and that's it, and we're not going to accept anything else. They started, this is an option available to you. We're going to start to offer this option. And so, in the circuit court, they have to have, we had to change electronic systems. We had to change our computer recording system. We went from one called JITS to now it's C-TRAC. And so all of those things are going to take time. For me to come in here and say on day one, I'm going to fix something, I think would not be the correct thing to say. I think to come in here, and I think to have some respect for what's happened here in Anderson County and the judges in this court, Don Eldridge's court, to familiarize myself with that process. And you could even, start a committee with the court, with the clerk's office, with some other people that are involved to see how that would work, how that would go. Involving more people is always, can be integral to the process.
Earlier, one of the before lunch applicants was asked, you're not from around here.
Right.
And, well, you're not from around here, and you're not in the courthouse with a lot of them. How do you see yourself interacting with the bar that regularly would practice in front of you?
So a little bit of background, I've lived in Anderson County the entire time I've been in East Tennessee. We lived in Oak Ridge for a brief period before we got robbed. And then we moved to Clinton. We moved here, my husband started a small business. He was a contractor. He worked with his father who had lived here for quite some time. And we moved out when I lived in Nashville and when I came to work in the Supreme Court building, I lived on Church Street. So I would, a condo in downtown Nashville. So for me, to go to the 3 acres I now own in Clinton and live in an extremely rural community, it was a change, and I wasn't sure how I would adjust. And, I think my application, it certainly gives the picture of what's happened to me since I've been here, that my husband, 2 or 3 years of moving here, he became sick with ALS and Lou Gehrig's disease. And so the citizens of Anderson County, I can't tell you how much their support and their care, You know, my neighbors in a neighborhood that I hadn't lived in for 6 months started mowing my yard. They've cut down a pine tree because they were afraid it would fall on my house, you know, and I didn't ask them to do that. We had a sewer problem and had to get a new septic tank, which is the first house I've ever had with a septic tank, by the way. But I now have a septic tank and a propane tank in the backyard. You know, and I can't tell you how kind they were. And, you know, and now, after my husband's passed, I think I also said that I wanted to become more involved in the community. So now I'm the president of the Homeowners Association in my little rural community. So, you know, last night, before this, we actually had our annual HOA meeting, and I am the president of the HOA. So, you know, I feel like I have become part of Anderson County, and it is my home. My husband now, David, he's a born and raised Knoxville boy. So, I mean, this is home, and I am, you know, we got here through friends who had been born and raised here, you know, born when there were actual gates in Oak Ridge, and so, you know, I've been familiar with I've learned about the history of our unique place, and even some of our rural communities. I think, you know, it's a beautiful place, and I'm happy to call it home.
We've alluded to previously the concept of robe fever. Some people may not like it called that way, but the senior members of this have suffered through it from time to time. Do you see yourself acquiring that dreaded disease for, say, someone from Chattanooga or from the big city of Nashville coming into your new home?
I'm not sure what.
Well, I mean,
can you explain road fever
are
a
we?
little better?
Are you going to look at two classes of people coming? Those that are from here and those that are not from here. So that if I come in and I may have a different style, say, than is normally practiced in civil cases. God forbid you ever see me do a criminal case. So in a civil case. And it won't necessarily be very civil if it's a contested, contentious type of case, and sometimes lawyers don't get along. So you have to call the balls and strikes. But if I've got a local, and I'm not necessarily the nicest advocate for my client, what are you going to do to me?
Put you in timeout.
Really good answer. He's been trying to figure out how to do that for years.
No, seriously. You know, and the different questions about how to address things that happen in the courtroom, you know, I do think that the courtroom should be treated with respect. I would try to put aside all biases towards any party. I think that is our job. And if Ms. Waters asks the question again, you know, I think we have to recognize that we aren't doing that as well as we should, and that we aren't even aware of the ways in which we aren't doing that. But, you know, I think I've also been able to go to judicial conference with Judge Thomas in the last few years, and so we've had some CLEs about bias training. We've had some CLEs about ethics, because in some ways I am also, you know, I'm not necessarily bound by the Judicial Code of Conduct, but as his employee, I have to be careful of the things that I do as they reflect on him. So, you know, I say that, and to, again, you know, other than putting you in timeout, to, you know, I would address that if necessary. I wouldn't say that I would call it, you know, have a bench conference. It just depends upon how ruly you plan to get Mr. Lawless. You know, and so there comes a time and a place to be authoritative, and there comes a time and a place to, you know, to sort of, you're the judge. Your courtroom decorum is important. And so, you know, I wouldn't necessarily want to take that approach every single time somebody from out of town came. But, you know, I think I could handle it fairly.
Okay. The other elephant in the room, to use your phraseology, is you're not from here. And if the governor were to select you, you'd have to bounce right in to a campaign.
Right.
And we already know that several others are going to be in that campaign. If you're successful here today and one of the three names go out, and Governor Lee appoints you, are you going to run? It's the first question. It's a two-part question, obviously. So, and I'll let you answer that one.
Yes.
And if the governor doesn't select you, are you going to run?
So I thought about that question as it's been asked earlier, and the answer would have to be, I don't know. I also, again, would go back to the Judicial Code of Conduct and whether or not I would even be allowed to do that as an employee of Judge Thomas. But I would certainly check with him first, just to get any sort of ethical conundrum out of the way, you know. And I also, like Ms. Crutchfield, appreciate the governors in this process. You know, I'm not sure. I would certainly campaign. I've talked to Judge Ogle about campaigning and what that entails, and you know, that idea of selling yourself of when it's necessary. And she said it's a lot easier than you think, although she clearly is pretty good at it. And you know, so I wouldn't necessarily. The answer is I'm not sure.
And that's a good, honest answer.
Yeah.
Mr. Chairman. Thank you.
Excuse me. If you're appointed to this position, tell me what Judge Capps' courtroom, how it's going to function.
How the court will function. You know, I think when we talk about things, we all are probably going to get up here and say it's going to run efficiently and diligently and all of the right, you know, and be productive and clear the backlog. And I certainly would have all of those as my goals. I also think the biggest thing about the courtroom is that for people to feel like they've been heard, the issue of injustice, or what does injustice mean, I think that's what it is people feel like they weren't heard or somehow the system failed them. I would like for them to come to my courtroom and know and feel that they've been heard, whether they get the right result or not, to feel that they've been heard. You know, and so I hope to do all of those things in this, you know, start on time, end on time, those kind of things. I personally will not be having jury trials till 2 a.m. in case anybody wants to know. You know, we had an issue, an opinion about, we talk about late night jury trials. 2 a.m. is something else, but, and they actually issued the verdict just past 2 a.m. So that would not be happening in my courtroom. I would be more than happy to work till late into the evening, but I think at 2 a.m. to render a verdict is for somebody's life is at stake. I know, I'm not sure about y'all, but I would rather be in bed. So, you know, I again, like I said, I've seen some trial court judges, and I've seen how they run their courtroom and keep things moving and expeditious. So I think that's what I would strive for.
In your application, and part of your, I think it's one of the questions about your experience over the years, and you worked for a short period of time as an associate. I'm not exactly sure where the firm was, but one of the things you note that I think you say you interviewed potential clients regarding family law, bankruptcy issues, you prepared legal documents, attended courtroom proceedings, and you say, given the extreme importance of these issues to the clients, I felt more oversight and practical solutions were needed. Tell me what you meant by that.
So, again, I was 24 when I graduated from law school, and so you say, well, how did you get here? At that time, now this was not when, you know, a lot of the new law clerks are named Caitlin, and they have tattoos, and they have, you know, it's okay to come in with purple fingernail polish now. You know, I didn't grow up in that era. I didn't grow up in an era where, I remember I was 12th in my class, and I had an interview with Armstrong Allen in Memphis, and I think it was noted in my interview that I had purple fingernail polish. So, you know, I also stand before you in a pink shirt. You know, so I'm a little crazy, you know, but what I meant by that was, you know, Bradley, I worked for him for maybe 6 weeks. And so I went with him to the courtroom, but instantly I was going to start to have interviews with clients alone about their custody issues and advise them and try to bring them into this firm. And I felt green. I mean, that's really, and there was no oversight. I didn't have, and you know, I think about what I wanted as a younger person was, you know, I kind of envy doctors. I think I mentioned that to you. You know, they have that residency, they have that fellowship, they have that oversight where they get some practical experience, and that we in law school don't get that. You know, we can do moot court or we can do mock trial, but nobody actually takes, you know, at least at my school at the time, we didn't actually go out into the courtroom. I had the job in the courtroom. I worked for Larry Rice at a law firm too, you know, pretty prominent divorce lawyer in Memphis. I worked for him and as a runner, you know, so I did all the grunt work. But I felt like these issues were important. Child custody issues, divorce issues. When you have people who come into your courtroom or come into the office and, you know, they work at Home Depot, they don't have the money to sit there and to spend hundreds of thousands of dollars arguing with their spouse about the car that they can't, you know. And so even when they would advise these people, there were some things that I saw that I thought more input might have been welcome, and, you know, and so that's really what I wanted, was a little bit more oversight. And I thought, honestly, if I'm going to do all the work myself, then I really will just go hang out my own shingle and get my own malpractice insurance. And that was really the way I felt about it. You know, I did not get paid much, and so, but I did learn some things. Most of the things I did there were draft the paperwork, marital dissolution agreements, parental agreements. You know, that was what we were mostly focused on there. So, you know, I think it's important. I have also seen a lot of green lawyers, a lot of, let's face it, ineffective assistance of counsel claims exist for a reason, right? Some bad lawyers, you know, and the more jury trials I read, I kind of realized I couldn't have been near as bad as I thought I was going to be. But, you know, Bradley also had a point. At that point, I was 24. I'd never bought a house. I didn't have kids. I didn't, you know, people who come in and they want you to advise them as we talk about experience in the trial court and things about that happen in life. I just didn't have that. You know, I had purple fingernail polish and wanted to go save bald eagles in Alaska. You know, I mean, I thought I still had that I want to save the world mentality. And so I moved on from that. And, you know, it's worked out to my benefit for sure.
Thank you. I don't have anything further.
Mr. Chairman, I have no questions.
Thank you.
Thank you, Mr. Chairman. Just a couple of questions, Ms. Capps. Thank you for your application, and thank you for your service to the state as a almost 20-year employee. Touched on it a little earlier in your remarks, but I think it's important. When you hear somebody say that they've suffered an injustice, what does that mean to you? Well, help me pick that apart a little bit about how you process that.
You know, I even was speaking with my husband at lunch about your question, because I think it's a complex question, really. You know, it's injustice means virtue. Is justice blind? All of these things that we like, these ideals and goals that we like to hold dear, you know, to ourselves as lawyers. It's probably why we became lawyers. It's why you guys feel the job that you do up here is important. But again, I think what that really comes down to is people feel somehow that the system has failed them, somehow that they haven't been heard, somehow, you know, and we can't make everybody happy all the time, right? I mean, that's just an impossibility. Nobody can ever make, you know, anybody, and a judge's job isn't to make everybody happy all of the time. But I do think that it's important to allow them to be heard so they don't feel that they have been marginalized or that they have been discounted or that their issues don't matter. You know, I grew up, we talk about gender issues, and I grew up with a single mother, you know, and so I had a lot of strong female roles in my life. And, you know, I was never told, I was kind of the first generation, I guess, that got to be told there was nothing I couldn't do as a female, you know. I do look around the wall, and they're all men on the wall. I mean, you know, I go to judicial conference, and they're still largely male and older, senior, you know, and so I think people need to feel a connection to the judiciary, and I think you know, I think the world is changing, and so I think that's the biggest thing is to feel heard. I don't want to come in here and make lots of changes, and all of a sudden, you know, so that's not what I'm angling for, but, you know, I think our society, you know, we would like to feel like the judicial system is working for us. And we have such biases in that regard from our particular perspectives these days. And I think, you know, I kind of like to use the dirty word moderate, you know, to moderate and to not necessarily be on one end of the spectrum or the other, you know. Somebody asked about sentencing and harsh, I think it might have been Judge Cope, asked about sentencing and harsh sentencing. I've seen a lot of trial judges, especially those that have been trial judges for 15 or 20 years who are known as harsh sentencers, or some that are known as lenient. You know, I have seen, and we don't have a lot of discretion anymore on the appellate court of changing that decision. Trial judges are given extreme latitude these days in the sentencing decisions they make within those parameters. And so, you know, each individual is different. And I think sometimes they don't feel heard, or even that all of those factors are taken into account. And so I think that's really, you know, I would like to prevent that injustice of allowing people to feel part of.
I would note for the record that for the first time on these walls, a female county mayor's picture will follow right over there. Terry Frank is the county mayor here, so her picture will be the first female on the wall. Which, with your experience at the appellate level, tell us how you feel about the death penalty. Just, you know, how does your mind work on that? What are your thoughts?
So I personally am pro the death penalty. I have worked on death penalty cases. To say that it's not difficult would be a lie. You know, the first one I worked on was in Judge Hayes's, with Judge Hayes. It was, I will butcher his first name, but it was Gadongale Berry, who was out of, I believe, out of Memphis, actually. And his underlying crime was, I think he had shot a 5-year-old child in a mega market parking lot. And so, as part of a gang killing. So, you know, they're difficult, but they're important. And I think, you know, our laws, regardless of my beliefs, whether I'm pro or anti, the law, we are in a death penalty state. And so, you know, I worked on Sedley Alley, who was executed 2008, I believe, but, you know, his estate is still filing claims about post-conviction DNA Act evidence and whether or not that evidence that he tried to have tested before his execution can now be tested. So I have some knowledge of those issues that come up, proportionality review, about sentencing, you know, death sentencing, bifurcated jury trials. And, you know, I think it's an important punishment that we have. And again, if our laws support it, then that's my job to utilize that and present that in any way I can.
Thank you, Ms. Capps. Thank you, Mr. Chairman.
Thank you. Mr. North?
Good afternoon, Ms. Capps. You mentioned your husband's battle and subsequent passing from ALS. How do you think that will affect you on the bench in dealing with that, as Ms. Crutchfield called, I think, a life experience in making the hard sentence on a criminal defendant, as opposed to showing empathy for the same defendants and the victims as well?
So I'll try to say the words without getting choked up about them. But, you know, my husband was 39 when he was diagnosed. You know, we got married at 35 and 36, and we were a little late to the marriage game, but we were going to have our 2.5 kids in our garage and our picket fence, and, you know, that was the plan. And I have learned at a young age that life doesn't always follow a plan. To say it was difficult and trying would be an understatement. My husband couldn't feed himself. He couldn't talk. He had no control over his own bowels. So my life became consumed with his caregiving. I also, through that, was an advocate for the ALS Foundation. I went to Lobby Day with Patty Lane and met the Speaker of the House and participated in those types of things in the way that I could. But I think that life experience is what makes, it's definitely, as Ms. Crutchfield pointed, it's what makes us good judges. And that type of experience and what I had to go through to get his care, insurance companies to advocate on his behalf. We, like it or not, health care is, you need an advocate. You need somebody to take you, the best care you'll get is the best care your advocate can obtain for you. I took my husband to Mayo Clinic. I took him to, he got a pacemaker in Cleveland Clinic. I dealt with insurance issues, and and then we had to deal with death issues after, And so I also feel like I haven't let that experience define me. I have managed, many people lose a close loved one and they can't really ever pull out from the trenches. And, I have since, I feel like, taken the reins, and I've married again, and, I am young, and I do see a long, hopefully pretty, less eventful life, but I am acutely aware that life does not always follow the plan. And so I guess I'm not sure I still answered the question as to how that would affect my decision-making. I think that it does allow you to have empathy. And I've pointed to the fact that everybody wants to be heard, but I don't think that our job is to make everybody happy. I'm not, like I said, here to change things in some drastic way to, my husband and I, we talk about, somebody had also talked about what I hope to maybe achieve in Anderson County. My husband and I, Derek, when we lived in Nashville, we visited D4, the drug court treatment facility out. At the time, it was the only residential facility that they had in the state. And so I think on 2 occasions, we went out there for the Christmas party, and we served lunch and pizza and, got to watch those people in that facility bring their children and have Christmas with those kids. And so, we do have a large drug crisis in the country and certainly a meth crisis here in Anderson County. There are some things that judges are implementing across the state to kind of deal with less nonviolent offenders with drug problems, and I think those are great. I look at, I know Judge Sloan gets a lot of credit, but he does some pretty great things. He's adopted 2 drug-addicted babies. He's got the facility for pregnant women. I think those are all ideals that hopefully we can strive for, no matter who gets the position. And so, I think all of those, I look back at the 24-year-old who wasn't ready with the life experiences, and I feel like that now I am.
Good answer. Thank you. Thank you, Mr. Chairman.
Thank you, Mr. Lancaster.
Yes, I do want to make this point. I'll usually make it at the very beginning. This process, those of us on this commission, we're committed to this merit selection part of the whole process we have in the state. And I can tell you, I know it's superior to most any surrounding state that we have, or most in the country. But it's wholly dependent on people applying and putting themselves through this grueling situation. And I want to thank all of you. Those that have spoken, those that haven't, but I just really appreciate it. And as a member of this state, just appreciate the system we have in place. So thank you. I do have one question. In this process, we always put forward what we can do. But I did ask Ms. Crutchfield, you get appointed, that we send your name to the governor and the governor puts you on the bench. Your first day, what's the biggest challenge you think you're going to have to address based on your experience? We've talked about, and we know about strengths, and you've done a good job, and I think you've talked about some of the things you haven't done, but what would you say, okay, I've got to get this under control right off the bat? What would that be?
Yeah, first of all, would be information gathering to really know what that is. I'm going to be honest, Mr. Spitzer talks about the grand jury backlog, and that listening to him sounds crucial as something to get going and moving. And that goes back to some of my weaknesses, that I'm not here in Anderson County, right? But I can appreciate the magnitude and with DAs and all of the work that needs to be done here. You know, there's also been some talk about the division of cases between Chancery and Circuit. You know, all felonies come through Circuit Court is the way it's set up here in Anderson County, which keeps the Circuit Court judge pretty busy, right? But I would also be willing to work with Chancellor Cantrell and any division of how that could be fixed. I'm not going to come in here and tell you I know how to fix that, because I don't. But I'm certainly open to discussing that and anything that could help Anderson County move more expeditiously and to, you know, Judge Thomas and I actually had this conversation yesterday because I asked him about it, and he said that he had offered that he was a circuit court judge in Blount County, and that he had talked to the chancellor in Blount County about the division of cases, and had offered to take some of the Chancery Court cases, but that the chancellor didn't want to make things change. So you can only do what you can do, right? But I think first and foremost, and with this pandemic and that we had, listening, I think the grand jury backlog would be crucial to get that up and running and moving again.
Well, thank you, and thank you for your service to the state.
Thank you. And again, thank you for applying for this position. It's an important one, and I personally appreciate your aspirations to change the type of service you're giving the state. You've had the opportunity to work very closely with 3 very fine appellate judges, and they're also good folks. So,
They are.
so if you're known by the company you keep, you've kept pretty good company for the last number of years. And Mr. Lawless touched on this earlier, and maybe I'm going to revisit it a little bit more. Some might say that appellate judges and appellate law clerks are working in a cloistered theoretical world. Some, perhaps like Mr. Lawless, would say, no, actually appellate judges are kind of like those scavengers that go over a battlefield after the battle's over and shoot the wounded. So, I mean, they're
A great way of putting what you used to do.
yeah, well,
It was pretty accurate.
now, see, personally, I used to think we're a shoulder to cry on and a port in the storm for the lawyers, but there's different points of view. But the point I'm trying to make here is that some might say that you've been dealing in the world of theory, and you're crossing the border into the world of practice.
Right.
And as you've seen from reading records, and I also ought to say, too, that I don't think there's only one path to the trial bench. There's not only one path to the appellate bench. It's a conglomeration of experiences that make someone prepared and able to do the job. And how do you juggle this theoretical versus practical?
You know, so again, that was, a question that I tried to prepare for, because it is true. We get to analyze, right? I get to read, I get to take it apart, and I get to read it, and I don't have to make a decision in the moment. I get the benefit of Lexis or Westlaw or whatever that is. But at the same time, through all of that, I feel like I have gotten a gut instinct, right? And so I've spent those 20 years in the theoretical, but it's also given me a good, solid foundation for that gut feeling of, on how to make rulings and dealing. I hope to deal with parties and lawyers. And the other question, I think, was if somebody was unruly or not doing a good job in your courtroom. I think if it comes to a certain point, what I would do in a practical situation, I think you should have some discussions with the lawyers outside of, off the record. But if it came to a particular point where you really believe the lawyer was no longer advocating for the defendant, especially in a criminal trial, I think you have an obligation to actually talk to the defendant, and nobody's mentioned that, and I think that's important. He has the right to the representation of his own choosing. He has the right to pick a bad lawyer if he wants to pick a bad lawyer, there are lines and there are ethical lines that we might have to deal with as judges, what amounts to unethical behavior, right? But if it's, you know, I've seen defendants want to choose their bad lawyer, you know, and so I say that I've seen all of those things in different situations, and now we do have these nice little fancy things that you can also have on the trial court bench, these computers there, you know, which hasn't always been the case. So if I was unsure, do have some time to look up, and I hope that if I don't know something, especially, you know, we'll talk about on the civil side, if I have to make a ruling and I don't know the answer, that I can use it, and I am efficient at using that and can come up with an answer in the courtroom in the moment and not have to take a recess so I can write a memo about it.
And it sounded to me from some of your earlier comments and answers to questions that you suffered from the lack of mentoring, we'll call it. And based on your experience as a young lawyer, what have you done, or what would you plan on doing were you to get this job, about helping young lawyers in that same circumstance that had the same self-doubts that you did when you were starting? Is that a priority of yours? As you figure that's somebody else's job? I mean, what's your reaction to all that?
You know, we have so many more lawyers coming out today than we used to, for sure, even, and, you know, and we can all look at BPR numbers now, right? Like, that's the tail, right? What is your BPR number? You know, and so there are so many more coming out of law school these days, and we don't get that practical knowledge. I am unsure how from the bench I could necessarily influence that, but I would certainly be open to the possibility of, you know, or how much I could participate in mentor programs or things like that. But I think it's important to it's important to the court system in general that we train good lawyers, and so that we don't just send them out there with willy-nilly and, you know, go represent this person who's who's gotten charged with 3 counts of especially aggravated robbery. Have fun, you know, and so I'll have to give you the honest answer of I don't know, but I would certainly be open to the possibility of exploring that.
Yeah. And I have 2 more questions, and one was really prompted by one of the earlier applicants who alluded to Justice Sandra Day O'Connor. And one of the things that Justice O'Connor said repeatedly was her firm opinion when she's asked what's the difference between men and women judges. She would say that, in her opinion, a wise old man and a wise old woman will land at about the same place. You agree, disagree? What's your reaction to that idea?
Do I?
And it's perfectly okay to say, no, I think women actually will approach things differently than
It
men.
also seems disrespectful to say you disagree with something with Sandra Day O'Connor.
She
So that
would-
is
she
not my
would ex-
job.
She would expect you to, if you
yes.
don't agree.
You know, I also recall in watching a recent movie about Justice Ginsburg that the question was asked to her, when is enough women on the Supreme Court enough? And she said all
When
9.
there's 9.
You know, and that wouldn't have been my answer, but that answer of there's somehow, you know, that I think for us females, and it was sort of, I don't think I've ever thought of it that way. That 9, you know, but there's been 9 men. There's been 9 men not presently, right? But, you know, for many years. And so, but I do also think that we hope that we would all end up in the same place. I don't know that I always agree with that. I mean, that is why, as much as we like to pretend like politics is not a part of the judiciary, certain judges pick certain judges, and likewise, why Democrat governors pick more liberal, you know, I mean, so we say that's not a part of it, but if, in all honesty, I mean, it has some bearing on who gets the job at a particular point in time. And so I can't say that I would 100% agree. We might come close within a sort of broad range, but I don't know that we would always come together.
And then the one last question is this. I'm going to go back to another U.S. Supreme Court justice that isn't mentioned that quite often, is Robert Jackson, who's probably in my opinion, one of the best writers on the Supreme Court in the 20th century. But Justice, what I wanted to ask you about Justice Jackson was this. He was very frequently cited a parable that he called the parable of the stonemasons. And don't go running to the Bible to find it, you won't. This is something that he made up, but he used it quite often. And the parable was this. You have three stonemasons working, and an observer stops the first one and said, "What are you doing?" And the stonemason said, "I'm making a living." He asked the second stonemason, "What are you doing?" And the second stonemason said, "I'm following the plan that the architect gave me." He asked the third stonemason, "What are you doing?" And the stonemason put down his hammer and his chisel. He looked up and he said, "I'm building a cathedral." Which one of the stonemasons are you?
So I'm going to go back to an answer I gave previously, and that the dirty word of moderate, I'd like to think possibly the second, that I wouldn't necessarily be interested in just doing the minimum to get by, but I wouldn't necessarily be interested in constructing a cathedral. So I think that's where I would land. This is important. A trial judge and what the business of Anderson County is important and crucial. And at the same time, I wouldn't come in here to overhaul it, build a cathedral, and make this some sort of example for, how to do things differently. So I'd like to think somewhere, that moderate position of things aren't always black and white. Like, again, I learned that at a pretty young age. Things aren't always black and white. They're not always, somehow in life we get the idea that they are. And most of life and judging is somewhere in the gray. And so I'd like to think that was the second one.
Thank you very much. Appreciate it. Thank you. We ready to proceed? Mr. Cantrell? And I believe Mr. North is going to lead us.
Good afternoon, Mr. Catherine.
Good afternoon.
Thank you for speaking with me earlier this week by phone.
It was my pleasure.
Tell us the basic nature of your law practice.
Since the beginning, a little over 30 years ago, I've done almost exclusively a litigation or a trial practice throughout the state of Tennessee and in the Commonwealth of Kentucky and other states. I don't do much, if any, federal practice anymore, and I've never practiced in the United States Bankruptcy Court. When I was younger, I did a significant amount of appellate work back at the time, maybe 50 to 100 cases. A lot of those were workman's compensation appeals that went directly to the Supreme Court, but over the years, I would say I'm a trial lawyer.
And you've had, as you indicate, thousands of bench trials, in your understanding, and several hundred jury trials. Is that correct?
Yes, sir.
You mentioned earlier in your opening statements that you had a definite plan going forward.
I do.
What is that?
I would not have put an application in for this position just for the sake of doing it. One of the things, listening to the other candidates, I've never run for a judicial position before. I think that there are things that need to be fixed immediately, and COVID has given an opportunity for us to look at how courtrooms operate in a different way. I think one of you all referenced earlier about this concept of Zoom hearings. And as someone who covers a wide geographic area, I cannot tell you how many times that I have dreaded getting up at 4:30, 5 in the morning, driving 3 hours across the time zone to sit for 3 hours for a 15-minute motion. And then you drive back home and you've killed a day for something that now we learned through COVID, we can hook up and say, you're going to be on at 10:45, we've got it done in 5 minutes. It's time we embrace that. There is no reason that we should not do that as a civil practice. There is no barrier. We have shown that it can be done. So that would be the first change I would effectuate. The second, and I take a little, I don't want to say I disagree with this, but I think it's like pulling a verse from the Bible. You can pull a number and spin a number any way that you want it. To say that the Anderson County Circuit Court is an 80% criminal court, 20% circuit court, is just simply not a true statement. That court is set up because when we combine the two positions, it's 1 week civil, 1 week criminal. those of us that have handled healthcare liability actions know that it is not unusual for a medical malpractice trial to last a month, if not longer. And the pretrial posturing that would go through will eat up days of a motion practice, and that would count as one case. Whereas Judge Elledge has at times handled over 300 to 400 pleas in a single day in criminal court. So it is a little unfair to say that it's an 80-20. It is a 50-50 court. The first thing that I would do on day one is I would clear the entire docket. Every case that is currently set would be taken off of the docket because the trial dates that are currently set are not feasible because of the backlog created in a combination of COVID, combination of Judge Elledge's health, which deteriorated pretty significantly when courts went back open. I would meet with the District Attorney General and the Public Defender, and we would immediately pull as many plea dates as we could, and we would stay there and get as many pleas off the case and as many cases from the grand jury to get ready for trial as we possibly could. I would meet with the circuit court clerk's office, and I would instruct them to contact every open civil case, beginning with the oldest first, and say, give me the list of the cases that are trial-ready today. Not that could be trial-ready in 60 days, 90 days, 120 days, that you're ready to go today. And we would lock them up 3 in a row. We'd have 1, 2, 3, or an A, B, C setting, and we would use our civil days to try as many cases that are ready to try. I would instigate a mandatory mediation order. Every case that is a civil case would be required to be mediated in order to get the backlog pushed out and moving. That would be day one. Day two, I would meet with the county mayor, the other judicial officials. We have had discussions in this judicial district for over a decade now about a judicial center. Even more rural, and I take umbrance with my brother from Davidson County. I do not consider us a rural county. We are a very highly educated, diverse, and a county with a rich history, and we take no backseat to Knoxville, Chattanooga, Nashville, or Memphis, but we need a justice center. We have one right across the street. And the only reason that it has not become a full justice center is the circuit court position was hesitant about moving. Chancery Court was ready to move. Juvenile court is already there. The public defender's office is to the side. The district attorney's office is already there. The 5th floor of that building has more floor space than this entire courthouse, all 3 floors of this courthouse. We could easily move the school system, which operates out of the 5th floor, into an independent facility, free up more court space in this system, and have a much more secure facility that complies with the witness safety rules. Right now in this building, we don't have a place to keep a victim or a witness away from a potential defendant, and I think that is essential. So that would be day two. So those are just some of the things that I would begin to get the system moving.
Anything else that you can think of that you believe need to be fixed, or as you say in your application, to improve the litigation process?
For sure. Our local rules haven't been touched in more than a decade. Our local rules pre-exist the technology that we have and are a little archaic. I would not allow or permit a motion to be filed that does not cite a procedural rule that supports that motion. I grow, I don't want to say amazed, but there are times that attorneys will just file a document called a motion and will just start saying things. And my response is usually to show up and go, these are really nice arguments, and this is a very well-written motion, but there is no rule of procedure that would bring this motion into this litigation at this point in time. And we could alleviate a lot of the motion practice if you would simply require the attorney to say, why don't we start with picking out the motion or the rule in the civil procedure rules or the criminal procedure rules that you're relying upon to be able to make this argument. I think that's a very simple fix. Judge Rosenbaum, who used to be in Knoxville, my all-time favorite judge, said the rules exist for a reason. We have them there, and we keep all of these secrets hidden in books that you just have to kind of open the book and look at it and, wow. And I think that if we change the local rules to streamline some of the process and say we're going to have simple requirements such as identifying your motion, how to get your motion set. I would eliminate the docket call. We still require attorneys from Shelby County, Davidson County, Hamilton County to come up here and spend a day to set a case on a trial docket that is only 6 to 8 months out, even if it's a case that's just been filed. With the size of staff that we have in our circuit court clerk system, we can go to an automated docketing system today. I would go to e-filing. One of the things that all of you all have asked the question, why aren't we doing e-filing? The reason is nobody has taken the time to do it yet. The school system got a significant amount of ESSER money to where now our entire county, there is no place in Anderson County that does not have internet capability. Our entire confines from Briceville to Oak Ridge, to Dutch Valley, to Claxton, to Andersonville, we are now totally covered. We all have all of our previous filings scanned into a digital database. We're ready for e-filing. How nice would it be to be able to just, as a judge, pull up the pleadings there on your computer as having to flip through boxes of files? So that's another easy fix that we can do, but it takes coordination. It takes being able to sit down and know how the system works. And I think being in a courtroom, you know what works, what doesn't work. And one of the fellows that's running his billboard says experience matters. I have the experience. I have been in a courtroom. I've been a judge. There are fixes that can be made. It just takes having the ability to say it's okay to change.
Let me give you an example of a frequently abused situation in Hamilton County. You send out written discovery around 35 days or so after it's due. The other side files a motion to compel without giving prior notice to the other side, hey, you really owe me this written discovery or something like that. Obviously, it's processed. It's set on the motion docket. It comes on for hearing. The responding attorney stands up and says 14 days. Other side says, fine. Judge says, next case. How would you deal with that? That is an absolute waste of judicial resources.
We used to actually keep an associate or affiliate office in Alabama, and I'm very familiar with how law is practiced in Hamilton County, and you roll up your sleeves and you all notice and litigate everything to death. We're a little more genteel in this end of the state, but
Thank you for saying that.
there you go. So I think here, the way that I have seen it done in courts that I've practiced before that I prefer is sometimes written discovery, particularly in civil litigation, it's not able to be answered in 30 days, and sometimes the answers that you're giving are just, we're waiting on medical treatment to be done. I think the proper way to do it is to redo your local rules and say, you've got X amount of time, you're going to submit the motion to compel with an affidavit of compliance where you have attempted to work out the discovery dispute with the opposing party. So it's an actual affidavit that the attorney has signed that explains what I have done, that I've called, I've sent this letter, this is the reason I've got, and then you would attach an order granting that motion 20 days out. There would be no court hearing, there would be nothing unless the other side filed an objection or a response, because you're just killing time. It's a way to bill and kill time, and I think that satisfies that issue, so that's how I would handle that one.
At some point, the trial court judges in Hamilton County got the impression they could not do that because that was a variance from the rules of civil procedure, which I'm not sure that that is the case, but they've been reluctant to do anything like that. They've been reluctant to make a requirement that you contact your opponent and say, hey, you owe me a little discovery, you going to get it to me or not? But that's
one of the things I touch on in, I think, my application. Judges and attorneys fall into this trap of, well, we've always done it this way, and this is the way we're going to continue to do it. The rules of civil procedure actually give the judge total control of how they're going to move the case along. For example, As a trial judge, and I rarely see this with the younger lawyers, if their expert gets called, I'm not going to wait until the close of proof to call my expert. I'm going to ask the trial judge to vary the order and let me call my expert, because I don't want the jury sitting there for a week and not having heard from the competing expert. Well, some trial judges are reluctant to do that, and you point to the rules and say, Your Honor, you control how the litigation flows and goes. That also counts to pretrial litigation. Another underutilized part of the rule is the sanction element. There is a sanction element of attorney's fees if you abuse the discovery process. And you want to stop discovery abuse, you set an attorney's fee award for attorneys that are blatantly abusing discovery, and you enforce the award at that time. You don't say, we're going to reserve this issue until the end. Well, that's a nothing. If you know that you're going to have to pay the cost of the attorney that has to handle this discovery dispute immediately, all of a sudden, these disputes are going to go away. So I would respectfully disagree with the judges in Hamilton County. I think they do have the absolute right to modify the way they're doing it.
You've taught law. Are you currently teaching law?
I'm not currently teaching. I taught for about 10 years at the University of Tennessee College of Law, and then I was a visiting professor at American University and have guest lectured. And I will still do the occasional guest lecturing, mostly on risk management for healthcare liability issues. I am interested in teaching again. As I have gotten my son to the point where he is close to independent living. If you notice on my resume, there was a lot of things that stopped in '99. We had a child born with cerebral palsy and severe developmental delays that became a primary focus of what we did. So I gave up my judicial positions, modified my practice to some degree, and started easing back from my teaching responsibilities. But I would be open to taking an adjunct position again. I enjoyed being in the classroom.
Tell us about, you and I had talked at length on the phone about your special needs son, but tell us about your involvement in the special needs community here.
I was appointed, one of the first judicial positions that I held was the governor appointed me to be an administrative law judge, hearing due process hearings related to special education law for school systems. When Benjamin was born, I obviously believed that became a conflict of interest, that it would be impossible for me to be objective as the parent of a special needs child. We were told after a lengthy hospital stay, we were in the hospital off and on approximately a year for his birth, that he would never be able to identify colors, would never be able to rock, feed himself, would have difficulty breathing independently, would have essentially no function. And there was a lot of research out there that suggested otherwise. And we became incredibly active in the special needs community, finding out what resources were available. We got him into a program in northern Georgia. We got him into a program in Miami, Florida. And he just walked across the stage in the end of May to receive an associate's degree at Roane State Community College. And he will take a full-time job in the Anderson County school system starting August as a special education assistant and working in technology on computers. Anything is possible. Any obstacle can be turned into an opportunity. And one of our goals that we're working on right now is we established the Connect Academy, where we work through the school systems and keep the students in under our purview until they're 22, because they're eligible for federal funding until they're 22, and we're building group homes to where they will be able to learn assisted living skills on Tuesday, Wednesday, and Thursday under the supervision of the Anderson County Board of Education. They will then use Monday and Friday to learn vocational schools. We're also in talks with a former law partner of mine who had been a judge here in the county for a while, Brandon Fisher, who now works with a company in Philadelphia, Pennsylvania, that we're trying to get them to accept Knoxville as their next community. They come in and they do pure work sourcing for individuals with disabilities. And we are one of the 2 finalists now with them. They're funded by the Terrible Towel people. If anybody's a Pittsburgh Steelers fan, 100% of the funds for the Terrible Towel fund this organization, and then they set up centers in parts of the country that work purely with people with disabilities to help get them into a vocational environment. And we're actively working to show them that East Tennessee is a very forward-thinking community. Anderson County has the #1 special education system in the state of Tennessee.
It's outstanding. On page 9 of your application, you say, "We need a judiciary that is unafraid to enforce the laws promulgated by the General Assembly and by the governor." As straightforward as that statement is, would you elaborate?
I think that you touched on it with the problem that you face in Hamilton County, to where you have judges that are reluctant to go, well, I don't know if the rules of civil procedure give us this. You have a tsunami of litigation that is getting ready to hit this state with the new enactment of the laws related to orders of protection. That is a pretty sweeping piece of litigation, and in my judicial lifetime, workers' comp would weigh in a night. I mean, it was sort of like we had workman's comp one day, and the next day, 1/4 of the lawyers were unemployed on the plaintiff and the defense side because we went to an administrative forum. Same thing with the Healthcare Liability Act, the Uniform Child Parenting Act. This due process law, no one has, I was reading it over the weekend, it's very vague. Laws that are written now are not necessarily written by lawyers. A lot of them are written for political talking points and purposes, but they are still the law. And we're going to have to get up to speed to deal with an area of the law where the majority of people are not represented by legal counsel. They'll go in, take out an order of protection. The spouse won't take out, they won't get an attorney. They show up, and now you have a fact scenario where it could be a lifetime order of protection. Well, immediately you're going to start seeing people jump to lawyers. We need an attorney for this. And you have judges that are going to be very reluctant, in my opinion, to be the first ones out of the gate to issue lifetime bans. Okay? Anytime a law changes, judges are hesitant, and I was listening to Ms. Capps because it was neat hearing a perspective from the appellate side. They always want to wait to get direction and see what the Court of Appeals gives them. Well, they forget that you are the first line of defense. They can't rule on anything until you make a decision. And so many judges are afraid to get overturned by the Court of Appeals. Well, that's what they're there for. It's like instant replay. I hated instant replay when it came on. I was like, oh, I got another instant replay. But you've got to follow the law whether you like it or you don't, or whether you're uncomfortable with it. Got to get yourself familiar with it and make a decision.
And you're right, the ramifications of orders of protection, particularly as it relates to the ownership of firearms, for example.
Yeah.
You have been a longtime and successful volleyball coach.
Yes, I have.
Do you intend to resign, retire, if you're
When you coach,
appointed this position?
I've coached at the collegiate and high school level since the early 80s, and I tell every coach that's ever worked for me, or every athletic director I've ever worked for, that your firing has already been determined. They've just not told you what day it is going to be yet. So I don't determine my fate as to how long I intend to coach, as long as we remain successful. Yes, I do not see anything. It is a non-paid position. I've never taken a salary when I've coached high school athletics. I'm the longest tenured volleyball coach in the state of Tennessee, the winningest volleyball coach in the state of Tennessee, state runner-up last year, and I have a senior daughter that is captain of the #1 ranked team for this year. We always just push practices back until I can get there. I have 3 other coaches that work with me that they don't need me. So I don't see that happening, but I could see myself getting fired at any moment. So once you quit winning, they no longer remember what you did for them. It's, what are you doing for me now? But yes, I would, my goal would be to still coach.
What about the attorneys that would complain during the course of a multi-day jury trial that, say, the judge has to knock off at 4 because he's got a volleyball game at 5?
We don't play until 6:30, so I typically don't appear for junior varsity games, so that would not be a problem. And I also set my volleyball schedule and my trial docket, so I really don't foresee that being a problem. And once my daughter gets the way through, I don't know how much longer. 40 years is a long time to coach, and I've got 9 championships, so I don't know. I'll get my 10th one this year. I only have 10 fingers, so I don't need any more rings.
And you're currently involved in a divorce proceeding?
I'm currently divorced. I was, at the time I filled in my application, I was involved in a divorce proceeding, but as I stand before you today, as of 8:30 this morning, I was divorced. Judge Pemberton granted my divorce this morning.
And your now ex-wife is the chancellor down the hall.
Yes, she is.
How awkward is that going to be in the future when you try to
I would s-
interchange cases?
I would say that that is the question that has been asked of me the most when I expressed an interest for this position. And I want to start out by saying, particularly for those of you that know my ex-wife, you will not find a finer person. We were married for 24 years and never had a single argument. There was never a claim of infidelity. We fell in that unfortunate category of so much time was focused on, and I don't want to say this as a blame with the children, but particularly with our son, that we did not spend enough time together on focusing on our relationship. It was an extremely amicable divorce. I didn't even hire an attorney. We spent the 4th of July together and went to the beach together. She is an incredibly brilliant jurist, and you won't find a finer person, and I would have absolutely no amount of awkwardness at all working across the hall from her, and would actually be honored to do so. She's a fantastic judge and a fantastic person.
Mr. Cantor, I'm going to turn it back over to the chairman. I appreciate your participating in this process.
Oh, thank you, sir.
Thank you. Mr. Lancaster?
Yes, well, that sort of answered one of my questions. You had a really specific list, and I appreciate it, of things you would do immediately. Some of those things, it seems to me, would require some collaboration, which, now that I understand it clearly, your ex-wife.
Yes.
So how do you change the local rules unilaterally? Where's the collaboration involved in that? How would you approach it?
The first thing that I would do is I would suggest a sit-down with the chancellor, because she has expressed similar frustration with these rules being so archaic. They predate her coming onto the bench. So she did not have any input when the current local rules were enacted either. We are unique in this state in that all of our domestic relations jurisdiction stays with the Chancery Court, and that was purely done as an incentive to get the state to grant us a chancellorship. We used to have a state circuit judge and a state criminal judge, and Buddy Scott was very influential in saying, I can handle both those positions if we can get a full-time chancellor as opposed to having a circuit rider that came through. And in order to build up the Chancery Court docket, they just reached an agreement that all domestic relations cases would go through Chancery Court. Well, we now have 2 general sessions judges. At the time, we did, and a juvenile judge. At that time, we had 1 trial justice court, which became a general sessions court, that shared 2 days a week in Clinton, 2 days a week in Oak Ridge, 1 day a week in juvenile court. Well, now we have 2 full-time sessions judges and a full-time juvenile judge. There's nothing under the statutes that prevent the general sessions judges from hearing domestic relations cases, which would take, particularly on agreed divorces, the more simple divorces, get those moving off of the docket. I think the chancellor is as excited as I would be about the opportunity to bring the court system into the 21st century and change the rules. So I think it would be a collaborative effort with her. We also, under the way that we do it here, we jointly appoint the clerk and master. The circuit court and the chancery court are both responsible for appointing the clerk and master, which is an appointed position that comes from the judiciary, and then we have an elected circuit court clerk. We have a very large circuit court clerk staff, relatively small clerk and master staff. I think we can get more bang for our buck from what we do with them.
You know, I'm actually, when I was in private practice, 22nd Judicial District, we had 4 judges, no chancellor. All 4 judges could sit in chancery and hear chancery court. We had 4 counties, and it was done so that each county would have court days each week.
Yep.
Some were very small, but it was done that way. It sounds to me that you all could do the same thing, that this historical issue, especially since you're on such good terms with the chancellor, this is a prime opportunity of recalibrating how the entire docket is done, not just domestic. I mean, I understand why that's how you got your chancery in the first place. Is that really practical? Is that possible? Is that even, I mean, you have some pretty broad range, pretty dramatic changes that you have proposed today. Is that something you're proposing also?
Yes, because if you go into a position and you just want to maintain the position or get reelected the next time, what have you really accomplished at the end of the day? What is your legacy? I liked what Mr. Lawless said earlier about taking a significant pay cut to assume this position. I will be taking a significant pay cut to assume this position. It's something I want to do. This is not a step up of a financial ladder. I have no political aspirations. I am a trial lawyer who loves the judicial system. I have spent my entire legal career studying trial theory and how to make the process better. This is an opportunity to make the process better. COVID has kind of cleared the field. It showed what didn't work, what is possible, what wasn't possible. We kept our school systems open. We didn't miss a day because we were able to go to a totally virtual school system within a 2-week period. We anticipated what was getting ready to happen the week before spring break, so we canceled school that week, and in 2 weeks we were able to go virtual, and we never missed a single day during the pandemic. We had Chromebooks in every student's hands. People said, well, that's not possible. Knox County shut down. The bigger counties shut down. We didn't. We looked at an obstacle and we turned it into an opportunity. This is an opportunity. Now, if someone comes up to you and says, well, yeah, and y'all have asked this question, I assume I will get it. Are you going to run? You know, what you're going to do this? I really don't care at this point if I make a decision that's not a popular political decision. This is an opportunity to where I've got a year and a month to make some changes that we should have made 10 years ago. And that helps everybody. And that's what we should be doing. If you're going into public service, go into public service to serve. Don't go into public service to get reelected again the next time.
The move to the 5th floor.
Yes.
I assume there's going to be others interested in that move rather than just the judges. How do you get them on board?
Everyone wants this except Judge Elledge was the stopping block at that point. He felt the elevation from floor to ceiling at the 5th floor was not enough of an elevation. Judge Elledge had a tumor that had been removed that had taken the hearing from one of his ears, and logistically he had some concerns about how the courtroom would work. The county mayor, 100% on board with this. County commission is on board with this. School system, which I'm a member of the Board of Education, 100% on board with this. Chancery Court on board with this. And everybody in the courthouse is on board with this because we just don't have enough space. As you can tell, this is an older building. We eat up a lot of our space with hallway and not functional space, where if we could take all of this floor and move it to the 5th floor, we have extra space that's there, and it's a more secure facility. It's a more up-to-date facility.
One last question.
Yes, sir.
I was reading your application, and I got exhausted because you do so many things. And I thought to myself, so what are you going to give up? Obviously, you can't do it all, and you will have a loyalty to the people of this county, if you're on the bench, to do that first. So what will you give up? Teaching? I obviously, I understand wanting to coach your daughter through her senior year. I can't imagine. I can't imagine coaching an athlete. But anyway, so my kids weren't. But but they had my skill set. But I'm curious because I know you have this concept. You're not lacking confidence. What do you think, if you had to give something up, what would it be? Let me put it that way. I'm not going to ask you what will you give up, but if you had to give something up, what would it be?
The first thing that I would give up would be the teaching, because currently I'm not doing it right now, and I have turned down offers to return to the classroom to see how this plays out. So that would be the first thing that I would turn down. The coaching, time gets everyone, and you get a point to where that would probably be the next to go. I have people that are trained, ready to take over for that position. And I would say this, you only get one life, and I have a pretty high work capacity. I don't play golf, I don't hunt, I don't really do anything but read the law, study cases, try cases, spend time with my family, spend time with the church. I don't have anything else. So I don't know if I would have to give up anything, and this would be an opportunity to pour my time into fixing it. I get very bored if I don't have a project to work on. And when the courts got shut down as a trial lawyer, that was a year that I got to spend every night playing board games with my children. And that was God giving an opportunity that most of us don't get. Think about, some of you guys are older than I am. If you could have a year back to where you could spend every night with your daughter playing a board game, how fun and memorable that would be. So I looked at that as turning an obstacle into an opportunity.
I do have one question.
Sure.
Final question. I think it's going to be harder for you than the other candidates. What's going to be the biggest challenge if you get on the panel and then the governor appoints you and you get on the bench? What's going to be the biggest learning curve, the biggest challenge for you that first day of court?
That's hard to answer because when I taught, everybody was into Star Trek. When I first started teaching, Star Trek was big, and I had this class that loved Star Trek, and I would make all these Star Trek references, and I would say, you've got to understand how things work on a starship. If you're going to be the captain, you've got to know how things work. I know how a courtroom works. I know how to get the rabbits moving. The most difficult thing for me will be when nobody shows up. That we have court, that it's like the opening day of a restaurant and everybody has settled all of their motions that day, and you get in there and it's like an empty courtroom. I actually checked on my wife's courtroom this morning before we came in, and everything had canceled off. They had finished, and it's okay, now I've got a full day. What are we going to be able to accomplish in this day? So I think the biggest learning curve for me will be how to best utilize that day I have been given, because we're not guaranteed another day. So when those days come, and they happen all the time, that there's a message left on the recorder, hey, we've settled this case, you can tell the jury not to come in. Well, what can I accomplish during that day that I've been given? So that, I think, would be my biggest learning curve.
Thank you.
Oh,
And
thank
I
you.
appreciate your application. No further questions.
Mr. Cantrell, thank you for your application and your service. Just very briefly, when I was county mayor, I had a man tell me one time, he said, Mayor, there are no problems, there are just opportunities. But he would call me often, he'd say, I've got a heck of an opportunity for you. So, it kind of faded with me. One question.
Yes, sir.
Very simply, with two parts. How would an opposing counsel that you have worked with in the past describe you in dealing with you? And then how would a partner that you practiced with describe you?
An opposing counsel would describe me, and it's kind of odd in that I have at least one person on your panel that has been an opposing counsel, so you could probably ask them directly. I think they would say that I am very collegial, that I don't argue motions that I cannot win. If we get into a courtroom situation of a trial, that I will do my best to win that trial, but I am hopefully would be described as gracious, and I value civility among all things. Of the partners that I've worked with, I am more proud of the staff that has been with me. The ladies that you see here have been with me decades that have come through. Partners come and go. Partners just, you know, I don't have a bad relationship with a single partner. Two of my partners left to become judges. One left because they got an opportunity to run a family business. I don't have any bad relationships. I think if they said anything, they would talk about, when I work, I typically have one person that I deal all of my communications through. I don't delegate. So my primary assistant, Carla Taylor, has been with me 25 years. I give instruction through her, and then I get responses back through her. When we have attorney meetings, I don't believe in delegating. If it's my case, it's my case. I've worked where they throw you a file and go, hey, here's an opportunity for you to work on this file. If it's my dog, I put it down. So I hope that's what they would, I hope they would speak well of me.
Mr. Cantrell, thank you.
Thank you, sir.
Thank you.
What you did miss was the staff back there when you made your comment. Sort of, there's a combination of laughter, smirks. God, why are we here now? Can we go back to the office?
When is this going to be over?
Exactly. Which, again, you missed that part of it, but, and to paraphrase one of the other members, I'm exhausted just listening to you talk. I mean,
I'm
you're
sorry.
one of those. Sorry, I just got fussed at.
Don't engage.
Yeah,
Don't
yeah.
engage.
No question, you're a high-energy person, but you're also a political person. You're on the school board.
I would not consider that a political position.
I would call it somewhat necessary to go to mental health court, but we won't
Yes.
go down that road any further than I just did. So you can run for this position, I guess is what I'm trying to tell you. Do you have an active treasurer?
No.
If the governor was to select you and you were to campaign and you were to have expenses, you would have to have a treasurer, correct?
Correct.
Okay.
Unless I self-funded, but even then I would have to have a treasurer
You still have
that
to
I
have a
would go
treasurer,
through.
right. I don't want to see you again because I'm on that board. I
Okay.
really
Yeah.
don't want to see you again. With the greatest, again, respect.
Thank you.
Can you put together a campaign? And how do you balance it?
I'm glad you asked that question, because if the governor appoints me for this position, my job is to come in and accomplish as much as I can in this next year. You do not see a Dale Cantrell for Circuit Court Judge billboard anywhere in this county. I do not plan on even picking a petition up if I make a decision to run until December or January. I may get into this and everybody goes, dude, you're awful. This is just the biggest mistake we've ever made. I need some feedback from people. I'm not a politician. One of the young men said, well, I'm going to run for DA if that came up. He ran as a Democrat the last time for this one, then flipped over to Republican. I'm not trying to climb a ladder, but for Judge Elledge, who is a dear friend of mine, becoming ill and this position coming open, and there was a need where people in the bar reached out to me to help fill a need. I don't know if I would have filled out an application Now, if I get in there and I am doing a good job, and I feel that I'm getting a good job, and I'm getting a good feedback, then I do plan on running. But as far as having, I think it's ridiculous to put signs out in June and July for a primary that's next April. And you all have used this term, being from here for so long. Not only was I born here, my parents were born here, my grandparents were born here, and my great-grandparents founded this county. So I have never been anywhere but here. I went to the University of Tennessee for undergrad, grad, and law school, and lived at home and worked most of the time. This is my home. I know everybody that's here. So running doesn't scare me at all, but I'm not going to be, this gentleman asked me about what would I give up. Campaigning is overrated. People know you, they're going to know you. You don't need to be putting out all these signs. Go out, knock on some doors, talk to some people. But they know you in this community. We know each other. This is a very close-knit community, but my job is to be the circuit court judge, not to be a candidate for the circuit court judge.
You're a high-energy person, which is a compliment. I hope I have that much energy in a little while, but how are you going to put up with, because when you're wearing that black robe and you're staring down at us, and we're obviously every joke you have at that point in time, to steal Bill Koch's comments on the other times, you're smarter than everybody, you're funnier than everybody. How are you going to put up with us mere mortals when we come tooling in? Exclude that Mr. North and I will be coming in from the big city.
Yes.
And yes, I was very impressed with the drive-in from the interstate. In fact, I was blown away coming into this community. But how are you going to put up with mortals?
It is humility. If you looked at my application, I was going to be a basketball coach before I became an attorney. I don't come from a family of lawyers. No one in my family would have ever thought I would have become an attorney. I was going to be a coach. My father hated the fact that I was going to be a basketball coach, but it was what I was going to do, or I was going to become a minister. I went to the start of seminary and worked for the Billy Graham Association doing youth ministry work until I was 30, and you had to make a decision to go into the mission field or to go full-time, and I just did not feel the call. I think three things have prepared me to not get black robe fever, and I like the fact that Ms. Capps didn't really know what black robe fever was, because I am very aware of black robe fever. I've had longtime friends that have assumed the throne, and all of a sudden it's like, who are you? What's going on? You know, all of a sudden you don't know anything anymore and you're wrong. But three things I think would help me. One, having coached teenage girls for 40 years, you learn that you are not the smartest person in the room. You will learn that you'll get a lot more done by charisma and by trying to persuade and to help and inspire, and it develops patience. The second is raising a special needs child. Requires an unbelievable amount of patience, to where you look at the day and what was accomplished during that day in different increments, and you set different goals. And then the third is, as a teacher, I have prided myself on being a mentor. We still operate as a law firm. Two of these young ladies that sit back here, one of them is a first-year lawyer. One of them is a 6-year lawyer. They came out of law school to come under me, and I mentor them on a daily basis. I get calls from previous students that I had 15, 20 years ago with questions. So I think the mentoring part, and I think that we are called to serve, there is a humility that has to come with that. And I would end with, and I'm sure, Mr. Ellis, you've been on the same boat. When you travel outside of the friendly confines of your county, I have been hometown. I mean, I have been hometown badly, and it doesn't feel good. It doesn't look good in front of the client. That's where you go to Justice Koch's court and ask for the mercy or the forgiveness. But having been there, he can best pity who has felt the woe. I have felt it. And I think that I would hopefully have enough grace and humility to realize that at one point in my career, I was sitting in that chair. And I'll end with this quick anecdote. If any of y'all remember Paul Dunn, who was a longtime attorney in Knoxville, they sent me over to the first firm I ever worked at to do a workman's comp trial. I didn't even know what workman's comp was. I didn't know what a PPD was. I didn't know anything. Nobody goes with me. They hand a file. Oh, this is easy. You just go do it. Watch a couple. You'll figure it out. I sat there, and they call me first. And so I don't even know how to begin. And so I kind of, walk up to the bench, and I said, Your Honor, I said, I really don't have a clue as to what I'm doing. And I said, Mr. Dunn, he came and spoke to our law class, and he seems to have kind of a grasp on this. Do you care to call him first and let me watch? And he said, oh, sure. So Dunn went, and I kind of sitting there watching how it went. And that gentleman, when it was done, figured out that I did not know, and he sat with me and got me through that trial. Him and Judge Scott essentially walked me through how to do a workman's compensation trial. Mr. Dunn's flipping through the file, and he goes, here's the permanent disability, and here's the doctor's depot. This is what we do here. That's how I learned. And hopefully, if I saw somebody that was that far in the weeds, you can gently help them. And the thing I could not tolerate would be lying. I think as long as you're honest with me and say, Your Honor, I'm a little outside the realm, I can suggest, let's take a recess, and why don't you look at this case or look at this rule, and then we'll come back and talk about it, as opposed to just blistering you when you don't know what you're doing. So I hope that was a sufficient answer.
Oh, it was from someone that was Lefflered in West Tennessee early in my career. So, thank you, A, for your application. B, your refreshing honesty.
Well, thank you.
Has been enjoyable, and I've got no further questions, and turn it back to you, sir.
Thank you. Ms. Water?
Good afternoon.
Good afternoon.
I am going to ask you the same question that I asked Ms. Crutchfield, which is, do you believe justice is blind regardless of a person's race or socioeconomic status?
I was hoping you would ask me that question because I talked to Karen during the break, and I thought that question came from left field. It's not something that any of us would have been prepared to ask, but it's a question that in this time we need to address. I think that justice in and of itself is a neutral concept, that's why Lady Justice is blindfolded with a scale, that justice as a concept is blind, is neutral, as an impartial. The practicality is that we live in a tribal society, and one of the things that the new judiciary is going to have to address is how you deal with political tribalism. If I were a criminal defense lawyer in this environment, I would figure a way to find a pro-Trump supporter, an anti-Trump supporter, get them on the jury, and know that they would never agree on anything, and I've got an automatic hung jury and an acquittal. So to say that people that are involved in the judicial system are totally fair and are going to give a equal shake to people of different races, faiths, color, religion, sexual orientation, particularly in a rural county in East Tennessee, would be naive. And I think as the fact finder, it is my job to try to keep the field as level as possible to ensure that everybody has an equal voice, and then be able to get to the point where justice gets to do the work. So I hope that was a satisfactory answer.
Thank you.
You're very welcome.
Thank you. Ms. Nelms?
All my questions have been asked, though I will say I had the opportunity as a young lawyer to be involved on the periphery of a case that Paul Dunn tried. He got a verdict I would never even thought about that was possible, but he did a fantastic job, and he was absolutely one of my favorites. So.
Mr. Cantrell, I just have a few questions.
Yes, sir.
The first is there anything you think we can learn from Ted Lasso if we wanted to be coaches?
I have become a Ted Lasso fan, by the way, and I think, yes, if you ever wanted to become a coach, a good coach can coach any sport. I think that literally, if you know what you're doing, you could show up and coach anything. And I have told our football coaches, and I never played a down of football. I went to a little rural school. We didn't have enough people to play, to have a football team. You give me the rule book in a couple weeks, and I'll be able to field a team. So yes, you can learn a lot from Ted Lasso.
I guess we'll find out in season 2 whether your theory
Yeah.
holds. Yeah. On a more serious note, and I can't attribute the source because this comment's been attributed to many different people, but the quote I'm thinking about is that a leader without followers is just out for a walk. And judges are leaders, and I want to compliment you on your candor and your clarity and your self-conscious about your plans on how to move things forward around here. And perhaps I am more worn down by 15 more years' experience than you have, I don't know. But it seems to me that everything that you say may have merit. And there may need to be time for change, but as one of my colleagues has mentioned, well, you got another trial judge that you got to bring on, and you seem to be fairly comfortable with that, but you've got a clerk and master to bring on, and perhaps that won't be a problem since you're a hiring authority. But you got an elected circuit court clerk, and from my experience, elected circuit court clerks are forces to be reckoned with, and actually on a statewide basis have stalled a lot of improvements to the judicial system. You've got DAs, public defenders, you've got the Department of Human Services that staffs courts in some areas. So there are a lot of people that are going to have to follow your lead. And if you're going to accomplish this, unless you're planning on doing it by judicial fiat, which I don't recommend, how are you going to get all these people at the same place at the same time?
There's two ways that you lead. You either sit on the sled with the whip and you beat the dog's backs and say, get us there, or you grab the head of the sled and you become the lead dog. I have relationships with every single person that you have named. I went to high school with the circuit court clerk. The county mayor's younger brother dated my sister when they were in high school. I have
And
been.
that's helpful?
Yes, it was. My father actually ended that relationship, but I have spent my lifetime in this community developing relationships with these people. And Mr. Perkey had asked the question, what would my partners or other attorneys have said about me? I think the more important question is, what would these people in the courthouse and the community say about me? And I think that 35 plus years of community service, working in the churches, working in the schools, doing the pro bono work that we do here in the system has given me credibility or gravitas that the other candidates don't have, to where I can sit down with the county commission, articulate a plan, and they know that I have the ability to get the plan done. They may not agree with every aspect of it, and they will want to have input, obviously, but they do know, and I have shown a history of being able to accomplish pretty large public undertakings, or I would not suggest them.
My final two questions, there's no good way to ask them.
Okay?
So I'm not trying to make a personal comment on my part or make a personal a personal indictment about you. As I said, you exude confidence and you exude clarity, and to me those are very valuable traits. You mentioned once in the time you've talked with us humility. Those two concepts sometimes are mutually exclusive. How do you balance those?
You go back to faith. Would Christ, and I know we're in a public forum, but would Christ have not exhibited confidence in the way he spoke and the way he led but still have humility about them. I don't think that the two are mutually exclusive. Confidence is often confused with arrogance. And I think a confident leader is totally different than an arrogant leader. A confident leader has a plan, a vision, a direction, and realizes that we have to have the humility to sit down and ask for someone else's help in order to them accomplish the goal, as opposed to simply issue a directive that you're going to do the goal. So I think that you can be confident, and we should be confident, but we should never be arrogant, and we should never forget where we came from. I did not come from money. I came from a poor background and worked my way through school. That has had a major impact on my life, and how I deal with people is how I'm going to be judged by people. So I think that confidence, as long as it's not arrogance, is there, and I think the people you surround yourself with keep you humble.
Do I hear you saying essentially that confidence tempered by humility opens up the possibility that other people might be right?
Certainly. I have learned, and I go back to a coaching metaphor, the greatest leaps I have made as an attorney or as a coach have come following my greatest failures. That if I lose an important game or lose an important trial, the first thing I'm doing is post-game analysis or a breakdown. Why did I lose that? And then if I have the ability to go, well, here's the error that I made, I can take something positive away from it and not repeat that error. So yes, I'm going to get it wrong. I guarantee you on day one, I will make an error. I promise you. And I guarantee you during this interview, I have made errors. I think somebody said this is being recorded. I'll go back and go, oh, that looks stupid. I shouldn't have said that. We all make errors, and if we get so big for our britches that we can't seek counsel from people we trust, then you're just setting yourself up for failure. So I think that ultimately, though, a trial judge, just like a head coach, and just like a trial lawyer in a litigation situation, has to be able to make a decision. That's rule number one. I've got to make it. I've got to have confidence with the information I have. And this has not been talked about anyone, but judging the credibility of the witnesses is one of the primary responsibilities of a trial judge. You have to determine sometimes, is this person being truthful, is this person not? Sometimes you're going to get it wrong. And if you get it wrong, you get it wrong, and you hopefully learn from your mistakes and don't repeat that.
That was a good answer. Thank you.
Thank you.
And the final question is this, that among the data that we routinely receive in applications like this are reports from the Board of Judicial Conduct or the Court of the Judiciary and the BPR. We received a spreadsheet of the complaints that have been filed against you, and I'm not asking you to comment on.
Sure.
I'm not, 16 of those complaints are water under the bridge. The part that I'm trying to reconcile is that in your answer, and what you said, and it's perfectly appropriate, you said that in every circumstance, all complaints were dismissed without a file being open, yet the BPR says that 3 of those complaints were subject to diversion.
Correct.
Can you reconcile?
I can. And actually, that was one of the things that Mr. North had brought to my attention. The majority of the complaints were where I self-reported that something came up, an issue, and I would do a self-reporting of them. The issues that were resulted in a diversion were all advertisement issues. Back in the day, we had just the yellow pages were there, and they passed a rule for a short period of time. I'm sure, Mr. Lawless, you can remember that you had to put a disclaimer on there.
That was rough.
And we had a local...
He remembers more than I do.
Well, we had a local attorney that went through the phone book, and everybody that didn't put the disclaimer, he reported us, and the BPR, I think, got inundated with those complaints, and they said, look, if you will come sit through a class, we'll divert those. There was a second complaint that Mr. North brought to my attention that was an error that I'm going to clean up with the BPR that did not occur. I had owned a title company that I had sold in 2002 to another group of lawyers. In 2003, a complaint had been brought against that title company for their conduct. They had self-reported. I was listed in there and was not made aware of it. I actually gave testimony in that hearing, so that was an error that Mr. North brought to my attention, so I'm going to clean that up with the BPR. The third was I gave testimony to the BPR in an open complaint involving a case that I was not involved in. It was in another court, but somehow it had been brought, our firm got brought into it in a companion litigation case, and then that attorney reported me and that I had mischaracterized the tone of the conversation. I had put in my affidavit that he seemed on the second phone call a little more aggressive and nervous, and he said that that was just an opinion, and had recorded the phone call and played it and said that he did not sound nervous or aggressive, and I stood with my things, and I'd never met this attorney on 2 phone calls. This is what I went, and apparently that complaint is still open, but it's, I would say, at least 6, 7, 8 months old, and nothing's ever come of it, and I don't anticipate there being any action taken
Well,
on it.
that last matter was what I was going to
Yeah.
ask you about, so thank you for thinking ahead. I have no further questions. Thank you very much for
Thank you all.
for applying. We are now at the end of the proceeding, and of course, I would be remiss if I didn't, on behalf of my colleagues, state how much respect we have for Judge Elledge. He's been on the bench here since 2005. I've graded his papers from time to time. Notwithstanding the Elledge time, which I think's a great concept that I think needs to get exported, he has set the gold standard for the trial judiciary, and Anderson County's been very blessed to have him. So whoever goes on to the governor and ultimately gets selected will have some big shoes to fill, some expectations about how courts should run that are high, and rightfully so. So first off, on behalf of all my colleagues, we want to recognize Judge Elledge and his contributions. Secondly, I want to thank all of you applicants for being patient with us, for answering our questions candidly, for participating in this process. We would not have a job were you not interested in pursuing this, and so we're grateful that you do. Third is that, as I told you earlier, it is our custom immediately upon the end of the personal interviews to take an initial vote. And we are going to do that as soon as I finish talking. Since we have 8 members present, it will take a vote of 5 or more affirmative votes to move on to the recommendation to the governor. It is not uncommon for us to reach that decision for all 3 slots on the first vote, but it is also not, it happens on occasion where we have multiple votes. If that happens, if we go on to second votes, and this may be theoretical, but what happens is if we have any candidates who receive no vote, then we drop that candidate and conduct a vote with anyone who has not already been selected to the governor. So we could theoretically pick one person, or one person may receive 5 votes. Their name would be on the list. 2 did not get it. 1 got no votes. Then the second round would be just against the 2. You understand what I'm saying? So that's how this process is going to work. So at this time, members of the commission, we have passionate purple ballots today. It's almost as purple as somebody's nail color, perhaps. Maybe this is more violet. Please take out only one of your ballots, mark round one in the top left, and as Mr. Lawless has reminded us for years, vote for three, not one, not two, not four. In order to be counted, you must vote for three persons. We will pick up the ballots, and since Mr. Lawless is acting as our sergeant at arms today, you will help with the picking up and the counting of the ballots.
It doesn't really take much to train me, does it? These ladies have done it very quickly. Any more down?
And please relax, this will take a few minutes, because we have to actually measure twice and only cut once, so.
I'm doing too much work this time. Oh, okay, really? Okay.
Sorry. Just give me.
Okay, I'm good. I am just so happy. Oh, you're making me do the high math now. I can tell. God. She's been trying for years, it hasn't gotten it.
Never, I knew this would slow things down. Bottom of that was around when we started. When we started, when we started advertising, I think I was on the Casino Park Association. No, it was in, but it was in late eighties, early nineties. Because I remember, it was a little bit from that, and then we kind of had to redo it a little bit. It was a real big issue. I remember not on subject. As it turned out, had somebody what was it in Memphis? I don't know. Oh, this is mine. You good? Get your place done?
We still got four. Take it away.
We've got, our house is a rambling old house. So we had to get kids stuff out. We got the bedrooms, we got the inside.
Much better.
Pretty much done the kitchen and cooking.
It's been good in the state.
We did redo the kitchen, but we had to fill this one spot. Anyway, but it's amazing, when it's done, it's going, you're gonna
We
love
have
it.
one course.
I've given Carrie my closet. They don't, I mean, our house is I've learned how to.
We did it on the first ballot.
Why? No, well, why, we only have one here now. Let's go. Getting there and getting back. Now, I think it's down to, how many candidates are there next?
5.
Bill, I'm not skinny enough to get by you.
No.
I'm sorry about that.
No. 50 pounds go a long way.
Well, I'm trying to figure out if it's going down to the interstate. The question is,
Let's see, we've got, how many of us here? We got,
Thank you. Do you want these folders back?
The only thing you really wanted to do.
well, let's announce and then we can pack our tents. I agree. Well, ladies and gentlemen, we have made 3 selections on the first ballot, and I will not prolong the suspense, but again, I want to thank each of you for applying. We wish those of you who are going forward well. We wish the applicant who is not going forward well that our decision is not based on our lack of appreciation for all your contributions to the legal profession in the unique and different ways you've contributed. We appreciate that, but according to the statutes, we have to follow the rules, and so we followed them. And I am going to now read you the names of the 3 persons who will be forwarded to the governor this afternoon. Ryan Michael Spitzer, Karen G. Crutchfield, and Dale R. Cantrell. Congratulations. Is there a motion to adjourn?
Motion to adjourn.
Second? All in favor, say aye. Aye. We're adjourned.
See everybody next.
Next week, next week? Yeah. we'll see. No, you, no, he's not going to
I
vote.
know, but we're gonna, he's gonna try to get his case continued.
I'll be there in
What are you, billing? Yes.
Yes. Billing,